Well, welcome everybody. Want to thank you so much for coming to, well, what is this? This is the 5th Faculty of Law Research Series event. And thank you so much for coming, for taking some time out of your day. I'm very excited about today's presentation. And so I'll be really quite brief. We are going to be hearing a presentation from a group of people, but the main coordinators of the group are Professors Ruby Dhand from the Faculty of Law and Professor Dipesh Prema from the Faculty of Science. And they're going to be presenting on a project that's titled Increasing Access to Justice for People with Disabilities in Congregate Care Settings During COVID-19. And this is a really exciting presentation because it's a multidisciplinary project, which is something that we really like to talk about doing, but it's really nice to actually see it in motion. And both Dipesh and Ruby will be talking about some of the details of different types of things that are connected to what they're presenting on today. And so just some quick housekeeping for today. As usual, we have coffee, tea, cookies, fruit. So please feel free at any time to just kind of get up and help yourself to some refreshments. We're going to have the presentation, and at the end of the presentation time, we're going to have some opportunity for some Q&A. So keep track of some questions and some thoughts, and hopefully we can engage in some really good discussion afterward. And so I'm not going to take any more time, but please help me welcome Ruby and Dipesh and their team to present.
Thanks so much, everybody. Welcome everybody in person. Thank you so much for being here, and welcome everybody virtually. Thank you so much to Professor Major, our research team, the TRU Faculty of Law, Kara, and the team for organizing this event and giving us this wonderful opportunity today. I'd like to acknowledge that the TRU Faculty of Law is located in our privileged claim space on the unceded traditional First Nations territory belonging to the Secwepemc people within Secwepemc. And it's with accountability and humility that our Faculty of Law strives to answer the call for truth and reconciliation in our work. It's an important day for us to reflect. And today I'd also like to wish everybody a happy International Women's Day. We honor the many women, girls, two-spirit, and non-binary people in BC and all over Canada and around the world who are so often the cornerstones of our families, neighborhoods, and communities. Our research today, as Professor Major mentioned, is around increasing access to justice for people with disabilities who are currently in congregate care settings during COVID-19 and who have experienced multiple hardships. This is a multidisciplinary research, and our team is combined with both expertise in the faculties of law and science. Our research has been aimed at actually producing law reform and policy recommendations to increase access to justice, and it's based on multidisciplinary community-led research to increase access to justice for people experiencing disabilities and mental health and substance use issues. So we're going to begin by recognizing and introducing our incredible research team presenting with us today. We've been working with an interdisciplinary, multidisciplinary research team of law students and science students, and also in collaboration with researchers, lawyers, and advocacy organizations in both British Columbia and Ontario. We'd like to recognize and thank our funders, which is the Social Sciences and Humanities Research Council and the Law Foundation of British Columbia. And thank you so much to our incredible, amazing research team today presenting with us. We have Odette Dempsey-Caputo, who's a senior lawyer and manager of the Elizabeth Fry Legal Clinic, and was also the supervising lawyer at the TRU Community Legal Clinic. We also have Janae Enns, who's been working with us for the last 2 years on this research as a TRU law student in her 3rd year, and also has a master's degree. And we also recognize Caitlin Cook, again, another 3rd year TRU law student who's been working with us for the past 2 years and has an MSc. And Caitlin's also the president of the TRU Law and Science Club. We'd also like to recognize the multiple organizations who've collaborated with us on this research, and that includes Hillside Psychiatric Center, Health Justice BC, West Coast Prisoners Justice Society in Vancouver, the Elizabeth Fry Legal Clinic here in Kamloops, Arch Disability Law Center in Toronto, And also we'd like to recognize the work of Professor Tess Sheldon at the Windsor Faculty of Law and her team of students who've been collaborating with us. So I'm going to now turn it over to Professor Prema to kind of introduce the importance, to give us an overview of the importance of doing multidisciplinary research, both in law and science, in the context of the pandemic, and also access to justice for people with disabilities.
Hi, everybody. Thank you for coming. So for those of you who don't know me, I'm Dipesh Prema. I'm in the Department of Physical Sciences, Chemistry, which is then in the Faculty of Science. You know, we started this project a few years ago, I think maybe 2016, and it's been really good, and we've come a long way since then. So I just want to give you a quick overview of where we started and where we got to today, and how it's actually kind of taken us to the two COVID projects that we're going to talk about today. So we started with a project about accessibility, so accommodating students with disabilities in science education, and particularly in the chemistry lab. So if you think about the chemistry lab, we have chemicals, we have equipment, we have safety issues, but there's a legal component there too, right? There's a duty to accommodate disabled students. And, you know, there's a big underrepresentation of disabled students in a chemistry lab for, you know, those two particular reasons. And, you know, we talked about a lot of the mechanisms that will allow us to increase that student representation in the following paper that's cited right there. You know, so that was published in 2019. And then since then, the work has led us to bigger things. So, you know, a number of invited presentations, but more importantly, we're also working with the Canadian Society of Chemistry to include the principles of equity, diversity, and inclusion, and accessibility in particular into chemistry education. And this, so the chemistry society is like the National Canadian Chemical Society. So I may be akin to the Law Society or the Law Society Association, or whatever you call it. You know, so that was kind of the first project that we started with, and then there's lead-ons from there. So a couple of projects listed there that we're also working on, and you know, with science and law, you can think of lots and lots of projects here, right? So other projects that have come up, medical marijuana, environmental sustainability. These are all projects that have a legal component and a science component where there is a dearth of knowledge, right? There's a knowledge gap. So the collaboration is really good. The two COVID projects that we're going to talk about today, or that, you know, mostly the others are going to talk about, are funded by the Law Foundation of BC, and then also by Social Sciences and Humanities Research. And this was a partnership development grant. You know, one of the big things about doing a project like this is the student opportunities. And, you know, before I talk about that, just to say thank you to all the students, because, you know, we do this work and there's only so much we can do, and then the students kind of take over. So, you know, thank you to all of these students, and most of these students are in law programs, but we've also got our first science student working on some of these projects too, which is great. And if you think about it, you know, there's a lot of law students who have a science background who can help here. But on the flip side, you know, I've encountered a number of science students who, you know, maybe want to go into law. So really it represents a fantastic training opportunity as well, which, you know, has led to, like Ruby mentioned, the TRU Science and Law Club for a start. Ultimately, what we want to do is maybe create a hub on campus, a center where students and lawyers, right, can come and talk about these projects and answer questions, real life questions, where other researchers on campus can come and ask these questions and find answers. You know, the number of times somebody will come up to me in the science building and ask me a legal question just because I work with lawyers is, you know, it happens almost every few days. So we definitely have a need there. You know, TRU is talking about a multidisciplinary graduate program too. So we could have a multidisciplinary PhD program soon at TRU as well. So all of these things, this is where we want it to go, right? This is what we're working towards, to create this new interdisciplinary, multidisciplinary program and research that can be used not just as training, but also to answer real life questions, which kind of leads to the COVID question, right? So when COVID came a couple of years ago, we looked at this. And again, if you think about this, there's a knowledge gap right there between the science and the law, especially with how much misinformation and disinformation there is out there today, right? There's definitely a gap there. And what we found was that lawyers are often concerned about the science behind some of these policies, right? Some of the science behind COVID, especially in congregate care facilities for people with disabilities. So, just to list a couple things before we move on, the use of PPE and its impact on virus transmission, increased use of disinfectants, chlorine-based products, infection prevention training. These are terms that we're used to as a scientist, as a chemist. If we're working in the lab, we're using these things or talking about these things every day. Even little things like putting gloves on and the proper way to take them off, just the simplest things that we know like the back of our hand is not like that for lawyers or anyone else. So to have this, more efficient way of tackling these problems, talking about these problems, and then leading to sort of science that informs COVID policies too, is where the two COVID projects that we're going to talk about today come from. Okay, so that's kind of the overview. I just wanted to let you know, we went from working kind of small scale to actually working for, with the Chemical Society of Canada, publishing papers, lots of big things, lots of funding. So I think we've come a long way in the last few years. But anyway, that gives you a quick overview of where we're going. I'm going to let Ruby introduce some of the other COVID stuff before some of the others carry on. Okay, thank you.
Thank you so much. I think Dipesh has given us a great overview of kind of the reasons why we began this project and these two projects in particular today. And, kind of the rationale for our multidisciplinary research and our focus going forward. We do recognize in our work, there was a huge recognition of how COVID has really had a disproportionate impact on people with disabilities and people experiencing mental health and substance use issues, and specifically for those living in congregate care settings. So just from the outset, I wanted to mention congregate care settings include long-term care, assisted living facilities, group homes, hospitals, mental health facilities, specifically those who are involuntarily detained, meaning those who are held against their will. It also includes prisons and immigration holding centers. So for our purposes, we've kind of had two portions of the research. In BC here, we focused on the experience of people with mental health and substance use issues living in mental health facilities, prisons, and immigration detention. And those experiences have kind of informed our research. And then in Ontario, we've been collaborating with Arch Disability Law Centre and looking at the experience of people with disabilities in long-term care, assisted living, and group homes. And we recognize that these facilities are congregate facilities where members of very vulnerable communities live in confined spaces with very high transmission risks of contracting COVID-19. So from the outset, we know from all the statistics that around 80% of the deaths during COVID and the pandemic occurred within these congregate care settings. However, there seem to be kind of a silences of the voices of people with disabilities, even in the media and so on. And I know Janae and Caitlin are going to be kind of they've been analyzing that research also around, well, where are the voices? What are the stories of people with disabilities? So we'd like to recognize that this research does involve a qualitative component. And that's also why we've been collaborating, really having meaningful collaborations with all these different community-led legal organizations who have been doing work on the ground. And they've been advocating for their clients, and they've been really arguing that, there's been so many curtailments of access to justice in so many different ways. From the outset, we recognize that people with disabilities and people experiencing mental health and substance use issues who are involuntarily detained in these congregate care settings are extremely vulnerable as a result of multiple different issues. That includes pre-existing medical conditions, consent and capacity issues, a lack of community-based resources, a lack of PPE, as Dr. Prema mentioned, psychological harm of COVID-19 public health measures. We have to remember that often people experiencing mental health issues or substance use issues may already have consent and capacity issues. They may not understand exactly what social distancing means, and that exacerbates already pre-existing mental health or substance use issues. Existing barriers to access to justice have been heightened, and there will be some analysis and conversation around visitor restrictions, how that's impacted people who are in congregate care, isolation, increased use of medications, and also the increased use of various types of liberty restrictions, and how that kind of also, when we think about the Charter and Charter protected rights, and also the Convention on the Rights of Persons with Disabilities. So thinking about the legal tools and what restrictions on life, liberty, and autonomy, what we're actually at place here with all the different public health measures for those who are in congregate care settings. So right now, I'm very honored that we're going to be having Odette Dempsey Caputo, again, who's the senior lawyer and manager of the Elizabeth Fry Legal Clinic, talk to us about her experience and also her work representing and advocating for people with disabilities during the pandemic and the impact that virtual hearings has had on those individuals.
So I just want to start out to say I'm really honored to be here. I wouldn't exactly call myself an expert, but I have been dealing quite a bit in this area. And one of the things I want to point out is there's been a real push to use these virtual hearings to access, and there is a place for that, okay? It's definitely been helpful if somebody can't get in. Now, here's the problem though. There is an impact with this technology. And even if we look, one of the statistics, and you can get this on the BC government website, is that when we start using video conferencing, so 98% of British Columbians do have access to what we call reliable internet. So reliable internet means that it's not dial-up, it's fast enough that it can actually handle these video conferencings. However, once you move outside of any of the major cities, that actually drops down to only 40% of British Columbians have access to reliable internet. That means that 60% of British Columbians do not have access to reliable internet in rural areas, okay? So that's already, even when you don't start taking into account people who may be having issues with disabilities, they're already at a disadvantage. So it's definitely, when we talk about inclusion and technical issues, I mean, in my experience, when we're there, what kind of things do we see? Clients may not feel comfortable participating by video. That can be for numerous reasons. People seem to have this idea that it's only people who are older who struggle to use computers. That is not my experience within our clinic. I think if you did, as we do more research, we will find that that's actually not the issue. A lot of these clients, their executive functioning just isn't probably at the degree that a lot of you are used to. They may not have come in contact with a lot of video conferencing or using computers. They may be used to Zoom when the courts are using Microsoft Teams, so then they can't even learn one system to be able to help them and be aware of it. So it's not even like they could learn one and then be okay against the different platforms. That's not how it is. There can be issues around if our clients have issues around schizophrenia or paranoia. It's very uncomfortable. I mean, the clients that I have will actually come in, and when they're done working with us, will ask us to destroy every evidence that they ever were in our clinic. And we have to explain to them that we can't do that because the Law Society, think of how much more anxiety they have when they know that it's being recorded, that it's actually on video. They're terrified to have their face on it. They don't know what kind of connections are going to happen when they connect up with their computer. So it's really not necessarily the best way to engage people who are struggling with mental health issues. So when we talk about the impact of virtual hearings, recognizing that video conferencing can jeopardize the fairness of the hearing. You know, if you even look at a trial, so a lot of our trials right now, just so you're aware, are happening by phone or by Microsoft Teams, even simple applications. Now, one of the issues I had, even if we're doing it by phone, okay, let's take out the internet. Let's say, okay, we can do it by phone. A lot of the clients, people with disabilities are often on PWEs, so persons with disabilities, so they have a limited income. Okay, they cannot afford, they may have a phone, they may have a cell phone, but they can't afford the plans that you and I are used to. What they are literally doing is they are downloading these apps and then trying to attend these hearings by app. When they do that, there's this echo, this constant echo, and the judges get frustrated, the judges can't hear them, or if they're connecting on non-reliable internet, then they are trying to access it that way. And, you know, it keeps cutting in and out. They may not hear things. There's not that same flow for direct and cross-examination, connection failures. It's just really hard for, even as a lawyer, so as an advocate and a lawyer, when we're even there present, when it's being done online, often we're not allowed to be in the same room. So we have to be in separate rooms. And so when we're separate rooms, one of the things that creates is that I'm not able to engage with my client. I'm not able to kind of help them. I might have to have an advocate sitting in there with them that's muting and unmuting them because they can't fully understand how to do that themselves. I've seen this on human rights mediations. It's just really difficult to kind of allow yourself to direct them. I mean, I've sat in court before and said to my client, if you start going off topic, I'm going to hit you underneath the table, because some clients are very difficult. They have difficulty expressing their story. They have difficulty telling their story. That's why they have us, right? So they'll go off on a long tangent that has nothing to do with anything. If you've ever worked in this area, you will be on the phone for 45 minutes and you may have got 2 sentences of what they actually need. So imagine that happening in court and how frustrating that is for adjudicators or mediators or for judges. They're getting frustrated. And luckily we have legal clinics like the TRU Community Legal Clinic and the Elizabeth Fry Legal Clinic that can step in and help those clients. But many people don't have access to that. If they're in a care home or they're in some kind of long living home, they are not going to allow us to come in and have that same kind of interaction that we might otherwise have. Like I said, it can increase anxiety of people with mental health issues. It can, with the paranoia and the anxiety. So really, we've just kind of seen this difficulty for clients to kind of access it. And like I'm saying, it's not that we should never have these things, but the problem is, I think this is an area, and I'm happy to hear that we have people here that are doing research into it, because it is such an important area to realize that there has to be alternatives. And I think especially when we're sitting here in cities and we're like, well, they can just go to the library. How does somebody who's in barrier just go to the library and access the internet? What happens if your hearing goes beyond the time that the library is open, or you can only book it for an hour? Then we talk about anxiety and paranoia. This person's now in a public setting where other people might be able to hear them, right? They don't control, even if they book a separate room, they can't control that separate room. So it's just, these are the different issues that we're seeing at the Elizabeth Fry Legal Clinic, and I've heard from the TRU Community Legal Clinic that we're all kind of experiencing when it comes to issues with virtual hearings.
Thanks so much, Odette, for speaking to that really important issue, because it really does highlight, in all of these congregate care settings, everything was launched into a virtual hearing space, particularly for people who were experiencing involuntary detention, immigration detention. The IRB was fully online on Microsoft Teams. Already, our mental health tribunals in BC were already, before COVID, were actually using teleconference. And so then with the advent of the pandemic, they've now started using virtual hearings. And I was we were consulting with them recently, and, this is going to be seen as like a post-pandemic plan of also what, looking at virtual hearings is kind of like the way forward for access to justice. So we recognize that there are multiple different opportunities for technology, as today we recognize that, but that there also can be the impact that it can, the disproportionate impact it can have for people with disabilities and people experiencing mental health issues and substance use issues. I'd like to turn it now to both of our amazing student researchers here. We've, as Dr. Prema had mentioned, we've been so grateful to work with such incredible research students and have the support of lawyers like Odette. And so thank you so much, Janae and Caitlin. You've honestly, you've put in so much work throughout these past few years and during the pandemic, and it's just been incredible. We are so incredibly grateful. So let's turn the floor over to Janae and Caitlin to share some of the findings that they found in both of these research projects in BC and in Ontario.
Great, thank you, Ruby, or Professor Dhand, I should say. For the last 2 years, I've been very fortunate to be part of this multidisciplinary research team. My research has specifically focused on how COVID-19 has impacted people with disabilities living in long-term care and group homes. So just for context, there is a disproportionate number of younger adults with disabilities living in large-scale long-term facilities. Although group homes are sometimes seen as the more desirable option because they often only house up to 6 people, there's very long wait times. So in Ontario, it can take up to decades for someone to secure a group home placement, and at-home supports can be incredibly expensive. So people with disabilities sometimes have resorted to living in long-term care. Professor Dhand has touched on how early into our research, we found most of the public attention and scholarly publications were directed towards seniors living in long-term care facilities. COVID-19 public reporting largely overlooked the disability population, and there was a significant gap in COVID research that targeted people living in congregate care settings. However, what was being reported on clearly indicated that congregate living settings were really the epicenter for COVID-19 cases and deaths throughout Ontario. To reduce COVID-19 transmission risks in congregate care, the Ontario government implemented a number of public health orders. In March 2020, the province issued a no visitor order that applied to most congregate care settings. This order was a complete prohibition on all non-essential visitors from entering the facilities, and it also banned residents from leaving the facilities. Notably, the province waited until about the end of April 2020 to limit employees from working at more than one care facility. So while residents were confined to their rooms without visitors or any outside time, staff were often working across multiple facilities, and this was one of the primary causes of COVID transmission across congregate care. The nearly 2-month delay in issuing a mandatory single-site work order for staff is estimated to have resulted in hundreds, if not thousands, of deaths during the first wave of COVID. Nearly 6 months after the no visitor order was issued, the province released guidance policy documents to help clarify the visitor restrictions for long-term care and group homes. The policy specified that essential visitors do include support workers and caregivers. However, up until this point, congregate care facilities were interpreting the no visitor orders very inconsistently. Many were not allowing essential support staff and family members into the facilities. And this is a really critical piece because often people with disabilities rely on family members for communication, personal hygiene needs, and even just meaningful social interaction, all of which really needs to be deemed as essential. Early variations of the visitor policies also encouraged telephone or video interactions to maintain that social contact with family and friends. However, this recommendation completely ignores how virtual interactions are often not effective or meaningful for many people with certain types of developmental disabilities. The visitor restrictions have gone through many variations, partly in response to lobbying efforts from the disability and senior communities. However, the restrictions are still being applied inconsistently, with agencies empowered to act as the gatekeeper in deciding who is an essential visitor and who isn't. The More Than a Visitor Act was introduced in the Ontario legislature in September 2020. If adopted, it would have provided a statutory right for all residents in congregate care to have access to their caregivers at all times, even during a global pandemic such as this one. But rather unfortunately, the bill did not progress, but activists and disability groups are still advocating for the government to reconsider this bill. There have also been horrific reports of the living conditions in congregate care facilities during the pandemic. Specifically, in April 2020, the Canadian Armed Forces, or CAF, was deployed to 5 Ontario long-term care facilities to assist in COVID outbreaks. The CAF reported back on the blatant disregard for infection control measures and the horrible mistreatment of residents. Some of the specific observations noted in their report included reusing medical supplies on multiple residents, staff using degrading comments, patterns of staff aggression and abusive behavior towards residents, and improper use of sedation medications on residents. There was also a lack of cleanliness reported, with cockroaches and flies noted at one facility and old food trays stacked in residents' rooms. Numerous studies have established a significant decline in residents' mental health since the pandemic. Literature is now using the term confinement syndrome to describe the mental health impacts COVID-19 has had on residents in congregate care. Confinement syndrome has historically only been used to describe symptoms of people in prisons who are living in solitary confinement. These horrific living conditions in congregate environments and the easy access to medical assistance in dying, known as MAID, is now encouraging the voluntary deaths of people with disabilities. More people with disabilities in congregate care are accessing MAID since its eligibility criteria was relaxed just last year. Family members of a disabled man living in long-term care who recently accessed MAID have publicly stated that they strongly believe the nature of his living environment played a big part in making his decision. Now, today, I really just wanted to briefly highlight some of these devastating impacts that COVID-19 has had on people with disabilities living in congregate care. As awful as it has been, at least there is a growing awareness around these important issues. The Ontario Human Rights Tribunal has recently found that the group home visitor restrictions were discriminatory towards a 14-year-old boy with a developmental disability. He was denied meaningful contact with his family and friends for over 6 months, and it resulted in physical and behavioral changes. And this case was really a major legal victory for disability rights, as it's the first one to really affirm the importance of visitation rights moving forward, even during a global pandemic. And a lot of the problems that I have introduced today are still ongoing and evolving. The pandemic has only highlighted the long-standing systemic discrimination that is inherent in the institutionalization and segregation of people with disabilities. Significant law reform is required to protect people with disabilities living in congregate care. First, visitation needs to be a legislative right for residents that are living in these facilities. Second, there needs to be more public oversight and accountability for the living conditions across these facilities. However, I do want to note that these are really just short-term actions. I think what really needs to come from this is a strong long-term political commitment to deinstitutionalization. Those with disabilities are often forced to live in congregate care because there are just no other available options. This is going to require reimagining what care looks like by prioritizing community-based services and home supports. But most importantly, it's going to require collaboration with disability organizations and community members to ensure that their personal autonomy can finally be respected. And with that, I'm going to pass it off to Caitlin. Thanks.
Thanks, Janae. For those that didn't hear, my name is Caitlin. I'm also a third year. But prior to coming to law school, the majority of my education was actually in biology. And so I spent a decent amount of time at the start of the research kind of looking more at the preliminary research coming out about transmission, ventilation, PPE, and then shifted towards kind of the impacts on the groups that were receiving a little bit less attention. We saw a lot more about long-term care coming out. We saw more information about hospitals than we were seeing about those in detention centers and those that were in mental health care. So you've already heard a lot, and there is a lot of overlap. So I focused a lot of my presentation predominantly on more unique aspects of living in these facilities, and there are some unique examples. A lot of this is high level. I'm really happy to answer questions if I speed through something too quickly, but there's a lot of different kind of avenues going here. So thinking first about kind of these access to justice issues, and something that we've been discussing is, again, this shift in society towards technology. At the start of the pandemic as a means to communicate with one another, but also to distance. But when we're thinking about recovery programs, mental health facilities, detention centers, most of these tech advances are not only unreliable, but they're also inaccessible. A lot of folks aren't even allowed access to these types of technologies to use, let alone have the either financial means or the technical means to operate these types of things. Now, this isn't just for hearings. This also means contacts with their family. This means contact with their lawyers. So we were seeing, especially at the start of the pandemic, a lot of folks completely isolated and not able to access their legal counsel. Imagine you're in a prison setting, you can't talk to your lawyer. If you're involuntarily detained in a mental health facility, you can't talk to your representative. You're completely isolated with very little options. And, well, unconfirmed, I will admit, I'm also going to attribute this to the lack of regular media publication of these stories. They are not able to outwardly express their experiences because they've been totally isolated in these facilities with no one to communicate to other than either guards or nurses, who are also talking to a lot of folks, but traveling between facilities. We're also seeing a lack of communication with their families. And we know with especially recovery programs and those experiencing mental health challenges, contact with your families and your friends are part of a major aspect of your recovery. And a complete cutoff from that is not only slowing recovery, but potentially preventing folks that are in involuntary confinement from getting to a point where they would be able to leave. We also saw, again, the same restrictions about visitor guidelines. So again, you can't talk to your lawyer on the phone, and now they can't come and see you. Can't talk to your families and friends over tech, but you also can't have them come and visit you. We also saw that a lot of patients specifically were strictly confined to either their own rooms or their own interior spaces. They weren't allowed outside. If those in mental health care facilities had the permissions to leave, they had those permissions completely struck. So now you're trapped in that setting, feeling again that you're kind of alone in this situation. And there's not kind of the options to communicate with either a doctor or fellow inmates now, or fellow patients, completely restricted. We're also seeing with court process kind of slowing down or delays in some court processes. Again, we're seeing a delay in those that are potentially capable of leaving. Should depopulation be an option in detention centers or mental health facilities, we're seeing a slow in that. And so you're again seeing people detained longer than necessary, which was an access to justice concern at the start of the pandemic and continues to be an issue. And depopulation isn't necessarily feasible for those in substance use treatment because they're there to receive treatment. They can't just leave. It's counterproductive. In many cases, also from a practical standpoint, these facilities were exceptionally vulnerable to the spread of COVID-19. Focus on ventilation improvements, the use of personal protective equipment, constant sanitation, isolation, social distancing are all challenges at the best of times in these settings. Ensuring patients or detainees are constantly wearing their own masks, washing their hands, challenging enough. And then we add on top of that poor ventilation or outdated designs for filtration and ventilation systems in these facilities. And then we combine them again with spaces that are too small to effectively social distance in groups. And we see a heightened risk for spread. We also know that due to the nature of these types of congregate care facilities, hand sanitizer, something that many of us have taken advantage of during the pandemic, was not provided because of the overarching risk that it will be consumed in replacement for alcohol. So just something that basic they don't have access to. Focusing still on some of the harder science of the issue, we also know that addiction can weaken the immune system, as can some antipsychotics and antidepressants that are being prescribed. Similarly, due to detention demographics that we see in Canada and in BC specifically, there is an overrepresentation of individuals experiencing respiratory illness or weakness in these detainment facilities and in mental health care and in substance use clinics. These groups are predisposed to a higher risk for respiratory viruses, which allow for a greater potential of spread. And then we have, shifting towards policies again, some alarming reports surfacing around the safety measures that were being taken or avoided with respect to the pandemic. First of which kind of stems from detention facilities. There were multiple reports coming out pre-vaccine release that these facilities were failing to separate detainees that were testing positive for COVID-19 and those that were testing negative, alongside a number of other sanitation risks. And it reached a breaking point at least one facility where employees at the Fraser Regional Correctional Center actually exercised their right to refuse safe work because of the treatment of those within the facility. It goes without saying that isolation failures directly contribute to the spread of infection, not only within the populations within those facilities, but also for all of the employees coming in and out of that center. And so partly because the prisoners didn't have access to justice in that sense, they evoked their own right as a sense of protest for worker restrictions to say, hey, these conditions are not safe, which in my opinion seems a little crazy that they had to do that, pardon the phrasing, but that workers have to step up for the rights because they cannot communicate their own risks is not a place that we need to be in an outbreak situation. Reporting of case counts and outbreaks was also a touchy subject throughout the pandemic. There were outbreaks in a significant percentage of detention facilities across the country, but there was very little coverage of these outbreaks. And in spite of the limited reporting around detention outbreaks, it still managed to overtake the reporting surrounding addiction and mental health facilities, which received almost no attention. Dr. Bonnie Henry was actually questioned about this lack of reporting closer to the middle of the pandemic, specifically with respect to patients being held involuntarily under the Mental Health Act in British Columbia. And the official release position was that there were certainly no outbreaks occurring within these facilities. Though cynical, it is somewhat difficult to believe for this to be the case when similar facilities across the world were reporting, to quote the rights group that spoke on this issue, staggering outbreaks in these facilities, and because of the existing communal conditions and pre-existing health concerns that I previously discussed. Not to jinx the matter, we are moving towards the endemic stage of this pandemic, and there are a few takeaways to carry on for potentially the inevitable next outbreak of a similar situation. As has been mentioned, there's a recognizable need for visitation to be a protected legislative right, not just legal counsel, but for support workers and family. Living conditions oversight and accountability, as Janine mentioned, and the commitments to deinstitutionalization and depopulation. But there is also on a policy side, a clear need for consistent planning and implementation. Many detention facilities, addiction centers, and mental health facilities were relatively free to come up with their own pandemic planning and to enforce them within their own systems. We need a coordinated plan with adequate oversight within these facilities to ensure that everyone is receiving the same care, regardless of where they are currently staying. Finally, there is also a need for a stronger commitment to information transparency and reporting with respect to these congregate care facilities. There is no reason why the numbers should not have been released to the public about an outbreak at an addiction center, even if it's a touchy subject. Same with a mental health facility. There's no reasons why these pieces of information should be almost behind a data wall where you need to know where to look and where to dig to find them. There's a lot to be discussed with respect to these issues, as I said, but I think it comes down to kind of a distilled overarching point that we can't turn our eyes away from some of the most vulnerable members of our community. In fact, we should be shining a light on their treatment because it's representative of what's going on under the hood. Disproportionate treatment and protection can only occur when enough people are looking away or are kept in the dark. Which brings me to my second point, allows me to be maybe a little bit preachy here, the value of interdisciplinary research between scientists and legal professionals. Professor Dipesh already kind of talked about this, but COVID-19, like many other modern global issues, has demonstrated the need for interdisciplinary communication and coordination. We live in an increasingly complex and interconnected society, both physically and socially. The reality we face is that modern challenges are increasingly multifaceted and require holistic cross-disciplinary solutions. Coordination within a specific sector or discipline is no longer going to be sufficient, in my humble opinion, but there is vast potential in interdisciplinary work. Bringing policymakers, legal scholars, and Western traditional scientists together allows that assembled team to tackle challenges from a variety of perspectives at once. For example, the development of ventilation and filtration regulations from a primary peer-reviewed scientific research study in coordination with trauma-informed and rights-based isolation and visitation planning. Additionally, through an interdisciplinary lens, a greater pool of solutions can be brought together and assessed as whole that would have otherwise been unnoticed by the individual groups. Perhaps there is a simple scientific solution for something that would require a lot of legal grunt work, or vice versa, that neither would have been aware of had they not communicated. Currently, there is a communication gap between scientists and legal professionals, not just in the language used, but in the comfort levels between the groups. A gap that is not only hindering progress on these multifaceted issues, but is also slowing down response time in these emergency situations. Building up these communication bridges, creating these interdisciplinary spaces helps address the disconnect and ultimately allows for a stronger response effort. Finally, spending the time and energy to create these dynamics in a non-emergent setting will allow for the necessary breathing room to properly address the inevitable growing pains of working with individuals from outside your own discipline, and ultimately reduces the stress of such teamwork should another rapid response be required in the future. And that's kind of all I have to say.
Thank you so much. Thank you so much, Caitlin and Janae, for that incredible overview and sharing those very specific findings and your incredible hard work on this multidisciplinary research. As Caitlin and Janae had mentioned, like the importance of this next phase is really key because we have been able to, through all of this research through these past 2 years, we have been able to come up with specific kind of equitable, disability-informed legal responses that would be really relevant, and legal recommendations and law reform recommendations, and also scientific responses that are going to be hopefully shared. We're in the process of sharing them with all of our nonprofit organizations that we've been collaborating with. And it's really incredible because that has been actually informing their legal work. And our hope is that that can also inform, I know, their test cases and their particular clientele in a really relevant way, and is specifically increasing access to justice for people with disabilities and people with mental health and substance use issues in congregate care currently. And we will be also throughout this next phase doing qualitative interviews and kind of having that opportunity to kind of hear the stories also, and documenting that in our next phase of research throughout this next year. And our plan is then to also continue working with the various legal organizations that I'm very grateful to also, including the Elizabeth Fry Legal Clinic, as I mentioned them at the beginning, West Coast Prisoners Legal Services, Hillside, Health Justice, and those are the ones in BC, and also in Ontario, Arch Disability Law Center, which as Janae kind of had given us a really fantastic overview, is also bringing forth multiple test cases on behalf of people with disabilities in response to multiple different visitor restrictions, the triage policies within the hospitals, and they've been doing a lot of work in that area. So it has been very meaningful, and all of them I know have been very grateful for the work that our students have been doing, and that we've been very grateful to the Faculty of Law for their tremendous support for this research. So thank you so much to everybody for engaging in this dialogue. I'm looking forward to continuing to update everybody about where our research is going and the future. As Dr. Prema mentioned, he had to go teach his class, but you know, our hope is that in the future we can have perhaps a graduate program, we can have perhaps a research center, but if any students are also interested in collaborating with us, we are very excited about that. We've worked with over 12 students now in the Faculty of Law and multiple students in the Faculty of Science. And so we look forward to further research in this area. And thank you so much, everybody, for coming. And I know we have time for questions, and I really wanted to keep time for that. So if anybody has questions for any of us here today on our panel, that would be fantastic. Yes, Professor Major.
I'll start us off. I'm sure that there's lots of juices flowing, so there'll be more questions. Well, first I was just wondering, you really got down into Ontario, BC, it sounds. But I'm wondering how much like comparative work between those jurisdictions, or maybe looking at other jurisdictions or outside of Canada, have you done, or have you considered it?
We are considering, you know, it's been an interesting dialogue to actually have, because when we began the research in Ontario, we started working with Arch Disability Law Center. And so just in case everybody isn't aware, there are a specialty legal clinic, one of the only ones in Canada, but they specialize in increasing access to justice for people with disabilities, and they provide legal services specifically for people with disabilities. They're a test case. They focus on test cases. So they bring cases forward on behalf of people with disabilities in more of the appellant level courts. And I had the opportunity to work there both as an articling student and as a lawyer. So, and I continue to work with them on projects like this. And they also provided the impetus and support for the Disability Legal Clinic in Vancouver, in BC. So it's been an interesting conversation, because when we approached Arch about this research, they were very excited to collaborate with us. And by collaboration, we mean that we really wanted to support them in their advocacy and their research. And so we wanted to have the opportunity to really also have that dialogue. And so right away they said, wow, well, BC is a really interesting comparator, because the visitor restrictions in terms of long-term care and assisted living facilities haven't been as severe as they have been in Ontario. And so that's going to be an interesting comparator for the next phase of our research. And we've also been looking at, Dr. Prema and I have also been looking at some of the impacts this is having, because we have collaborations with other organizations in Saskatchewan and Alberta, and also the way that they've handled the pandemic, also in terms of the vaccine rollout and so on. So it will be a very interesting comparator. We did see in Ontario, there were specifically policies that seemed to be discriminatory for people with disabilities. For instance, the triage policy, which gave priority to people who didn't have disabilities for receiving kind of life-sustaining treatment in hospitals. And Arch did a lot of work around that, arguing that that was discriminatory. And they're still trying to work on the visitor bans and the visitor restrictions, as Janae had mentioned, and they have had some success in multiple different cases. But the comparator with BC is really interesting, because we have had a different approach. We obviously have a different kind of focus in BC also around where the visitor restrictions are going to go, but also looking at the impact of the pandemic and the COVID-19 policies for people who are in various types of other types of detention too, has been a really interesting comparator, even in Ontario. So thank you for that question, but we do see a lot of synergies and a lot of options also to look at, well, what are other jurisdictions doing? And that has really come into play when we've been talking to lawyers all over the country about these issues. So our plan is actually to expand this research in multiple different ways, and we can see that happening through our collaborations with the faculty also. So thank you. Yeah, Professor Myers.
Yeah, no, this was great, fascinating. So, you know, research on housing needs and give us some new ways of thinking about law and access to justice. And my own research looks at mis and disinformation, legal mis and disinformation, and thinks about a comparative to, for example, medical mis and disinformation. It's very valuable in the context of thinking of. And as you were talking about the examples researching, thinking about congregate care settings, for example, we know there's a lot of public interest reporting on senior citizens. That sometimes more invisible than that is, you know, things where it's like the mental health situation or people with disabilities, and in the examples that you were giving, I was thinking a lot of times what it was is that perhaps maybe this is one way of saying it, like a very zealous one-size-fits-all approach to preventing transmission of airborne disease means super social isolation and cutting off people from their resources, or so it has a disparate impact. To my mind, it seems like that I can see how that was the case and may continue to be the case in some ways, but I think we're moving to a different phase now. Let me explain what I mean by this. Curious to get your thoughts on it, because I think the phase that we're moving into now is the phase where we're going to accept endemic COVID, and we're going to increasingly get rid of public health requirements like for masking and for vaccines. And now I think what will happen is for people who are particularly vulnerable because of their age or because of a disability or because of a mental health issue or any other variety of issues, are going to be more vulnerable because of the fact, not for the same reasons they were before, but for the very opposite reason that everyone else is ripping off their mask, and now all of a sudden it's transmitting and it's really harming the most vulnerable. So I just wonder, what's the through line in terms of, I think there's lots, but it doesn't really, it puts you on almost a different side of the argument as we go into phase 2 of the pandemic. So I'm just curious if you could address your minds to that, or talk through that at all.
That's a really fantastic question. I mean, you're right. Like a lot of our work has focused on kind of the impact of a number of the different restrictions and public health measures that were put into place and kind of the disproportionate impact. But I think one of the huge themes that we've recognized too is that there were multiple issues and problems to access to justice, specifically for people with disabilities, people experiencing mental health, substance use issues already pre-existing before the pandemic, and those that were heightened, right? And so I think that's one of the key questions, is that's why we think it's so important to actually hear the stories of people who are currently in these congregate care settings, because this is their home for some of them, right? This is their home, this is where they reside, but also hear their stories, but also really collaborate with legal organizations that have been working so tirelessly to ensure access to justice, because that narrative is going to be different, right? Like, what does a post-pandemic world look like? What is an appropriate, equitable response? Even in terms of the vaccine rollout, thinking about accessibility to the vaccines within congregate care settings, ensuring there are more depopulation efforts. There is more deinstitutionalization, as both Janae and Caitlin mentioned. There is more of a conversation around access to justice, the impact that virtual hearings is having currently, because that's a huge conversation around law reform. And also a political commitment to just recognizing that people are going to be disproportionately impacted. So some of the questions that have been kind of raised also for us is, like, even for those living in the community currently with people with disabilities, like home care has been curtailed in so many ways, right? So people with disabilities who require tube feeding, not available anymore. Used to be available before. Now the price of that is up to like $35 to $40 an hour. And there's usually a minimum of 3 hours, right? And so all of those options, all of those home care options, transportation, accessibility options that were available because our healthcare system wasn't so overwhelmed, right? So I think it also is going to involve a really interesting multidisciplinary collaboration with psychiatrists, with healthcare providers, physiatrists, physicians advocating for people with disabilities, really recognizing that. I think having this multidisciplinary conversation with lawyers at the table is really key. I think that's what's going to have to be part of that conversation, is not just having these conversations in silos. One huge collaboration that we found has been really helpful is working with Dr. Dagg and his team at Hillside Psychiatric Center, ensuring that we are having constant collaborations with psychiatrists and hearing their stories around, here's what kind of resources, here's the problems that we've been facing in the healthcare system, and also with physicians around, you know, what can we do actually to ensure there are more nurses and social workers and psychiatrists and physicians who are able to really support, and disability-led organizations. I think having more disability-led policy would be kind of our aim, but I'm going to kind of defer to also our panelists here. So are there any thoughts that you want to share for Professor Meyer's question?
Yeah, it kind of actually ties into the question.
Sure, absolutely.
It's just a brief comment. I've been looking at some of the international responses around visitor restrictions, specifically in congregate care facilities, and I've been most interested in some of the European countries that have completely gotten rid of them. There's a couple countries, the Dutch government is one that comes to mind. They have passed legislation where you cannot have an all-out like prohibition on visitors anymore. So it's a legislative right for all residents in care homes, care facilities to have access to those essential visitors. And I just found that really inspiring. And then I also looked into, there's been a lot of COVID specific research since those policies and legislative amendments have come into play. So there was kind of, you know, it's always a risk. You let visitors in, there might be massive outbreaks of COVID, deaths, cases, what's going to happen? So I think that was why a lot of, including our governments, have been really reluctant to ease up on these visitor restrictions. But what we can see from some of these international countries is it didn't lead to an immense amount of outbreaks. In most cases, one of the studies, there was only one COVID case across. It was a pilot study of 5 facilities. So it was just amazing results. And I think this ties back into, we are reaching a new era where I think we're revisiting visitor restrictions, we're revisiting mask mandates, social distancing, but there still has to be some protective measures in place in order for these things to actually succeed. So yes, let's bring visitors back into homes, but we have to still be protective and safe about it. So a lot of times that means wearing a mask and just sanitizing, you know, going back to the basics sort of, but I think these studies have really shown that that can go a long ways, especially for the long term. So yeah, does that, I think, kind of answer your question a bit? Yes.
One of the things I'm particularly interested in is governmental oversight and public oversight of care facilities for whichever one of these categories one might put them in. And I'm struck by the way in which the Ford government in Ontario had terminated all of their own site inspections of long-term care facilities, the LTCs. And then we see extraordinarily high death toll there. And I'm just wondering the degree to which, granted those site investigations were occurring in a pre-COVID environment, but nevertheless, where we withdraw government oversight of government facilities as well as privately owned facilities, is you're seeing in your studies so far is that where that government oversight withdraws, that the problems of isolation, of pestilence within the facilities, the soil, the bedding, etc., all of that just seems to escalate because nobody's watching except the people who are working there and the people who are stuck there. And do you see any differences across the country?
I can talk to it a little bit, but
in that kind of pattern?
Sure, I have a brief comment and then I'll pass it off to Professor Dhand. I have been particularly interested in public accountability. Right now, it's very under-resourced. There isn't a lot of inspections taking place, but I think you've touched on, it's really important to note that almost all of these long-term care facilities had numerous health infractions long prior to COVID. Like these are really long-standing issues. And the problem with these inspections is nothing really comes from them. There's, I would say, no enforcement, really. You kind of get these warning slips and hopefully something changes, but they don't. Some of these facilities have just stacks of infractions that span over decades. So that's really disheartening. And I think COVID has also really brought that to the forefront because obviously conditions in these facilities have worsened since the pandemic, but through a little bit of investigation, you can clearly see like this is a long problem. So there is a lot of push right now for public accountability. Some groups are advocating to just get rid of all profit care facilities and have them all government under the government umbrella. But there's a lot of controversy around that too. And really what I think makes the most sense is to push deinstitutionalization. These care facilities don't seem to work no matter if there's enforcement, if there's oversight, it just isn't a good model. I'll pass it off to.
I was just gonna add kind of like a precursor to that. We're talking about oversight and like a pullback of oversight, but in regards to especially detention centers, we want to see oversight first because there was none. And so one of the issues with a lot of the detention centers, especially like either mixed security level and immigration detention centers, was that there was no oversight. And the reason why, for example, they could have settings where people that were testing positive for COVID, who were cellmates with people who were testing negative, just weren't separated. The reason why that stuff was allowed to happen was because there was no one looking. Everyone was in the dark about it. And I think there's also kind of an unwritten kind of conversation around the fact that especially in the BC prison population is predominantly Indigenous folks, and kind of it's like a double entendre where their voices are not being heard. Not only are they not able to access traditional medicine, but they're also not being able to like protect themselves in a situation where just generally speaking medically, a lot of Indigenous folks do have a predisposition to respiratory infection or respiratory illness or a weakened kind of immune system. So as much as yes, pulling back on oversight, and yes, we do need a measure, especially regulations or even from a scientific perspective, to prevent this from falling back to normal. In terms of detention centers specifically, I would like to see oversight to begin with, if that kind of makes sense.
Absolutely. And, you know, you raise a really important question because that's some of the key issues that we found, like collaborating with all these legal organizations who've basically said from the beginning, there has never been enough oversight. There's never been enough resources. But now we're talking about a broken system, which is becoming even more broken, right? And so what we've even recognized, I wanted to mention, like, it's important to hear that involuntary detention for a lot of people experiencing mental health or substance use issues, this is in the civil system. Like we're talking about the civil and forensic, but we're talking a lot of those individuals are people experiencing like they haven't interacted with the criminal code at all. We're talking about people who are having a health issue, right? And yet they're held against their will, right? And so thinking about that's why working with various organizations and thinking about how legal advocacy can actually create access to justice and looking at various other alternatives, even for long-term care. But that's going to take a lot of work for community resources. And there's going to have to be a lot of more resources put into for caregivers to actually be able to respond appropriately and to be able to provide those resources, and also care teams within the community. So we have been thinking about that in terms of law reform recommendations and how do we create more resources in a way, and also legal resources. I think it's important to recognize all the different organizations that we've been collaborating with are nonprofit. These are all legal clinics and legal organizations that, you know, they're not for profit. They, you know, this is a very challenging time also when we think about if there were more legal organizations, thinking about the impact that the cuts of legal aid have had in BC versus Ontario. I think that's an interesting question. The fact that there are over 100 specialty legal clinics and legal clinics there versus the types of legal clinics that we have here in BC, and kind of the dearth of legal services available and advocacy available for people with disabilities and people with mental health and substance use issues is a huge kind of aspect of the research also. But that question will be ongoing for us to tackle. So, and I see that Dean has a question also.
And he actually said that, you know, you've got to trust scientists and the welfare state, because, you know, they look it up as science and then they say, it's good for you to take this pill, and everybody takes it. But if the science is bad, you know, the reaction will be bad and the policy will be poor. So I think, you know, for us, it's a kind of a crossroads. And Jeffrey said, you know, yes, is this lesson historic? You know, we saw what happened, we're not happy with it, so close the chapter. And I think the answer probably that. Because it remains an issue about the vulnerable in our society. And yes, we do have the need to protect, but in that protection, there's an element of paternalism that becomes state policy. And, you know, I think for the first time in a long time, we actually have to say that the scientists are 2 steps ahead of each other, because this is something that they were talking about in their way. So I suppose the ongoing answer is just, will the law take journalistic sort of take on this, or will there be more autonomy? What's the balance in that? I don't think the answer is, one that's good today and good tomorrow. It's an ongoing sort of same plan. And the law always tries to catch up with science. But I think in this case, it's got a mix of the hard science and what it's limit to, and also behavioral science. My uncle died of living disabilities, and everybody said, do you know what? The worst thing is actually to be in a situation of being captive, because of something that's not your doing.
Yeah. Thank you so much for those insights, Dean Millard. I think, it raises so many questions for us around where the future is going to be and kind of the importance of us trying to do this type of multidisciplinary research, because we've even been able to learn so much from our amazing research team, and having that combination of dialogue between students in the Faculty of Science, students in the law faculty, and hearing the stories also of people with disabilities, and hearing like from the lawyers that we've been working with too, and understanding what the clients are going through, right? And I think there's just so much need where hopefully we'll be more equipped moving forward, and we can think about more multidisciplinary research projects in the future, and hearing about the lived experience piece is really key, because all of us, I know right now, I can say all of us have a loved one who has experienced a disability or a mental health issue, substance use issue, and who probably has experienced living in a congregate care setting at some point in their life, or will, right? And so we can also think about, well, how are we going to change things, and what does the future hold, and how we do have this opportunity to actually have these dialogues and this conversation to perhaps make meaningful change in that way.
I think also you've put forward a really relevant kind of topic that's going under the radar right now, which is, again, that gap between how scientists are functioning and how policymakers are functioning. So as I'm sure everyone knows, like, science is an ongoing process, and that's kind of what's happened with the pandemic, is that recommendations were given, and then it turned out better science refuted those original recommendations. But when you have scientists acting in isolation of policymakers, you don't have the fluid response time. And so we could say, like, I won't try and estimate a number because that would be irresponsible, but there was a good chunk of time where there was science demonstrating that there were specific things that were working and were not working, and it took policy a long time to catch up. And that, I think, really does speak towards the necessity of having an interdisciplinary team from the forego, kind of as soon as we see something like this happening. And I don't want to be pessimistic, but I don't think this is the last pandemic of this sort that we will see. And it would be irresponsible going forward to not immediately have policymakers and scientists kind of working together to come up with fluid solutions, so that as soon as new information changes, we can adjust our strategies. And again, kind of going towards Professor Meyer's research, really tackling disinformation as soon as it starts. There is a general lack of distrust in the system because we saw that lag. And I think that lag of response really did contribute to people not trusting the responses that were coming from medical scientists. And if we can address that by showing, no, there's collaboration happening and we're changing things as soon as we know them, even if it's not perfect, it's getting better. So I think that's also something to kind of take away from this, is that it really does need to be a team effort between different disciplines.
Are there any other questions? Well, with that, I just wanted to say thank you so much, everybody in person and everybody virtually, for really supporting us and hearing our research and supporting our research in this moment and engaging in our dialogue. So thank you so much, everybody, for being here.
Thank you. Thank you very much for sharing your research with us. Thank you again for joining us here to hear this and engaging in some conversation. There's quite a bit of food and coffee, so please feel free to stick around and continue to mingle and ask more questions. I'm sure that there are more conversations that could be had. And just one little housekeeping thing as well, just to kind of signal, we have one more presentation as a part of the research series for this academic year, and that will be on the 29th of March, and that will be Professor Morris will be presenting with one of his RAs on his research surrounding municipalities and a relationship to local Indigenous communities. So please stay tuned for that information as it comes available. Otherwise, thank you again for your presentations. Thank you for coming, and please enjoy the food and rest of your afternoons. I'll turn it off. Absolutely. Yeah, thanks for a great presentation, Ruby. That was excellent.